Good morning. The PMLA cases, Prevention of Money Laundering Act. Nowadays, very sensible because only politicians, ministers, and high rank government officials are being trapped by Director of Enforcement and others. Therefore, the political advocates always stays residential advocates, we can say political residential advocates applies and they fight, they have some influence only by third degree method used to get orders, all these things are there. But there was some amendment. That amendment brought in force by adding some more offences in the schedule of the, so the PMLA Act deals with the schedule of cases. So that schedule of cases will be there. So some of the offences were been added, 420, 467 and other offences. After committing that offences, if they can launder the money. What is money laundering? You must understand that earning by illegal ways and thereafter siphoning and bringing white collar. The offences 217, 409, 465, 467, 468, 471, 476, 120B IPCs were added. These all are the offences. Now they can invoke PMLA cases. So the one more thing, first you must understand that the 2012 this amendment was brought with effect from 4th January 2013. 420, 467 and Section 13 of Prevention of Corruption Act has been moved to Part A of the PMLA schedule. Therefore, for these offences, so there is possibility of your cases are coming to on your table also, even for small shots, earning 1 crore, half 1 crore, not multi-crores. Or at least 50 lakhs, so many things. So you will be prepared for that. First of all, you try to understand that the crime numbers are being given by NIB, NCB and local police, CCB, etc. But so far, Central Investigating Agency are concerned, they only give report number, ER number, IR number. Initially they will have a file of information, then they file crime cases for offences. Then they will furnish crime number and file charge sheet. And so far PMLA cases are concerned, if your bail application before the special court was not considered or any other case is not considered, you have to approach the Honorable High Court only directly before the division bench. At present, PMLA cases are being adjudicated before Honorable 6th Division Bench, headed by Mr. Ramesh and Mr. Lakshmi Narayanan J. So for that, one more aspect I would like to share with this judgment AR 2025, Supreme Court 1940, AR 2025, Supreme Court 1940. Here actually what had happened, this Prevention of Money Laundering Act was brought into force 2003 only, and as I told you, the amendment provisions which was brought into force 2013, the other offences were included. So therefore the accused in case of AR 2020 Pradeep Kumar 1945, Supreme Court 1940, Pradeep Nirankarnath Sharma was Director of Enforcement, another. So his tenure as a collector of Gujarat Bhuj district was 1st July 2005. So he filed an application before the trial court stating that when the offences were alleged to have been committed, the PMLA was not in force. Therefore, but however, a special court dismissed his discharge application filed under 227. Then he went to High Court. High Court also not considered any merit to consider the discharge application. Then they went to Supreme Court. Supreme Court has categorically discussed, had a clear verdict of ratio decisionity under 142 Constitution of India that these money laundering offences is continuing offences because involving economic offences necessitate a thorough trial, unearth complete chain of events, financial transaction and culpability of accused. Therefore, they say it is continuing offence. They say utilization of proceeds, alleged layering and integration and efforts to project such funds as untainted constitute element of a continuing offence under PMLA. So they have held a rejection of application for discharge is right. So go through the entirety of judgment. Don't avoid all these cases. Keep slowly to understand. Spend a few times just loitering in the verandas and shadow tree. Go and listen. Watch the court proceedings, how the others are arguing. Best wishes.